In this chapter, we're going to be discussing the scope of practice of an EMT and what scope of practice really means in the general healthcare field, patient consent and refusal of care, which is something that we run into almost every single day in the field, and some other legal issues that you might run into. So, what is scope of practice? That scope of practice can be applied to any healthcare professional, and it defines what exactly they can do or practice on with patients. It includes skills and procedures that you can do, and it's usually determined by national law, state law, or local law statutes and protocols. For us, our scope of practice usually can be found through our protocols. So standard of care, this kind of goes in hand with scope of practice. Standard of care is what a similar person with a similar amount of training would do in a similar situation. So as it applies to us, it is what would an EMT with the similar training and experience as you do given the similar call that you're on. As long as you follow the standard of care, so what someone reasonably would do in your position, it does greatly reduce your risk of having legal action brought against you. So the two big things to take away from these slides is scope of practice is what you can do, and a standard of care is how you should do that. And this is another video that we showed in class. It's about 10 minutes long, goes over a lot of the legal terminology. If you want to be able to see this video, I can send you a link to it separately. So now we'll move into patient consent and refusal of care. So what is consent? As EMS providers, we're going to deal with several different types of consent, but as a whole, consent is permission for you to assess, treat, and transport the patient. The first type of consent we'll go over is express consent. Express consent is the general consent we're going to get from the vast majority of our patients. That is someone who is legally with it and able to understand everything that's going on has to tell you that you need to, or that you can treat them. If for some reason they do not have the legal capacity to make decisions for themselves, say they are unconscious so they can't talk, or they have some sort of altered mental status so that they aren't making sound decisions, or if they are a minor under 18 and there's no parent around, then we fall into the realm of what's called implied consent. Implied consent is assuming that they would give us their express consent if they had the legal ability to do so. So expanding a little bit further on implied consent, especially when it comes to children and mentally incompetent adults, because that's most of the times that we have an implied consent. In every state, minors are not legally permitted to provide consent for refusal of care or for treatment. So we have to go to implied consent until we contact a parent or guardian. So if there is a parent or guardian not on scene, some things that you can do is try to contact them via cell phone. If you're trying to contact them via cell phone for refusal of care, say it's a minor injury that you're called for and the patient doesn't need to go to the hospital and the parent is refusing transport to the hospital, try to have a witness or someone who is not your partner be able to hear the conversation that you're having with the parent, have it on speakerphone. A lot of times we have a police officer who's on scene witness, just so that you have more than just your word against the parent's word of what was said during the phone conversation. There's some possible exceptions with minors that let you get express consent that's not from a parent or guardian. The first one is in loco parentis. That comes into play a lot if you pick up a child from a children's camp or from a school. Oftentimes, before the child attends one of these places that will have them for a long period of time, the parent will sign a form saying that the school or camp or wherever they are has their express consent to make medical decisions for the child. Another way that you can get express consent directly from the minor is if they're emancipated. Emancipated means that they legally are seen as an adult at that point. Some things that typically make a minor emancipated is if they have a child of their own, or if they've married before they're 18, or a few other circumstances where they are responsible for themselves and living on their own, and they have a legal document saying that they've been emancipated. The most common one that we run into is if they've had a child before they're 18 years old. So for the most part, when we're talking about implied consent with a minor, us as EMS providers can treat until we are told otherwise for a minor, because we have the implied consent that if a parent was there, they would want the child to be treated to the best of our ability. This becomes kind of a separate issue if we bring a patient into the emergency department. They have opposite rules typically of, unless if it's a life-threatening illness or injury, they will not treat a child until they have express consent from a parent. But for us, we are seeing that until we are told otherwise, we should be treating the child to the best of our ability. And this just highlights that minors who have children usually are emancipated, and also minors who are serving in the armed forces. If that happens to be a case, typically they are emancipated as well. There are some adults who are incapable of making informed decisions about care. These are typically ones that are in state custody or in group homes. Typically, whoever's in charge of the group home will have the legal ability to make express consent, but they typically fall under the implied consent rules for us. And usually we're only called if the group home thinks that the adult should be transported, and whoever has the ability to give consent is already giving consent. Sometimes we run into instances of involuntary transportation. What that is when we have an adult who is legally able to make their own decisions, typically, and is with it enough right now, but we still have to transport them because of something going on. Typically, this is when a patient is considered a threat to themselves or others. That would be suicidal or homicidal. That falls under Part 941 of the Mental Health Law. That has to be enacted by a police officer, and what a police officer can do is legally detain them under what's called a mental health arrest for up to 72 hours until they are cleared by a medical physician. In order to fully legally invoke this, you do have to have a police officer present or some sort of mental health professional, but typically we go for police officers for this type of arrest. So if they are not already on scene, make sure that they come before you start transporting, because they have the legal authority to say that this person has to go, and they'll go under their custody. If you do have to restrain a patient, we typically want the police there beforehand, and then they can restrain the patient. But if you have to do it yourself, make sure that you use soft restraints that are capable of immediate release. We're going to discuss this a whole lot more when it comes to behavioral emergencies later in this course. So there are many instances when patients refuse care from EMS. This can be care as a whole. This is typically if someone calls 911 for someone else and they weren't aware of it, they can refuse our care as a whole. Or sometimes they'll just refuse parts of care. It can be a treatment that they're refusing or transport to the hospital. The vast majority of the times when we have patients refusing care, it's for transport to the hospital. These are the patients that might not be injured, they just needed our assistance getting up because they fell down, and they don't see a need to go to the hospital to be evaluated. So whenever we take a patient refusal of care, we have to be very careful that they are legally able to refuse care. So things that we look for is that they must legally be able to consent to care, or if they fall under implied consent, such as a minor, they can't refuse it. Patient must be awake and oriented. We're going to discuss proper orientation later in the class. The patient must be fully informed of the risks of refusing care. So if you have someone who doesn't want to go to the hospital, you have to explain to them the benefits of going to the hospital and the risks of staying home, and they have to be able to repeat that back to you or show some sort of comprehension that they understand that they have risks of refusing this care that we're recommending. Once they do all that and they meet all the criteria, you have to have them sign saying that they refuse this care. There's a standardized form used in this region that has all this laid out. We'll be able to show that to you later. And despite all these precautions that we take, if you take a refusal on someone who cannot legally refuse care, you might still be held liable for that. When someone's refusing care, You have to take all possible actions to attempt to persuade the patient to accept care and transport. A lot of times this involves us actually sitting down and talking with them. Sometimes you can get family members involved. It really depends on the reason why they do not want to go to the hospital. Yeah, it can range from anywhere from they don't want to spend the money to go to the hospital, they think that they have to take care of their pet or their family member or someone else, they don't have the time to sit in the hospital, and sometimes, especially with the elderly population, these are people who have a very good chance of dying if they do not seek care at the hospital. So if you actually sit down and talk with them and explain your side and then listen to what they're saying and say that you understand this, but this is how we can remedy these situations, that can go a long way in having a patient not refuse your care anymore. And this falls under what we discussed in day one for being a patient advocate. Sometimes being a patient advocate is knowing what's best for them even if they're refusing care and trying to explain it to them in a way that they will understand and change their mind. If they still are refusing care after you've talked to them and you've had family or friends try to talk to them, um, one last step we can take is consulting medical direction. So that's going back to the online medical control that we talked about in day one. You can directly call, typically we call Upstate because they're our resource hospital in this area, and tell a doctor exactly what's going on, why you think the patient should get this care or transport to the hospital. And you can ask them to talk to the patient directly, because sometimes patients don't respect EMT's opinions nearly as much as a actual medical doctor. And if they hear a medical doctor say, no, you really need to have this treatment or come into the hospital, they will sometimes change their mind. And sometimes just having a law enforcement member come onto the scene will go a long way. This definitely is the case when it comes to people who are a little altered. If they see a police officer come in and say, hey, you really need to go to the hospital, they'll listen to that just because it's someone with a badge that they have gone all their life saying, oh, we need to listen to what these guys say. So, what are the risks of beginning treatment and transport without getting consent from the patient? A lot of this comes down to, it opens you up to legal liability. If we start touching someone without their consent and they're able to give consent, that actually does fall under assault charges, because as a broad stance, if you touch someone in any circumstance without them wanting it, that is assault. Other risks, if we transport someone who is legally able to refuse transport and they don't want it, that is removing someone from their home without their consent, that falls under kidnapping laws. So you can get into some serious legal problems if you have someone who is able to consent and you're doing something against their will. So if a patient refuses to sign a refusal of care form, we really try to tell them the need to sign this care form, and typically patients who want you gone will listen to you saying, well, all you need to do is sign this form for us and then we'll leave. Of course, this happens after we explain all the risks and we go through all the checklists that we've talked about before. Typically patients are okay doing that because they are sick of talking to us at that point. But if they absolutely still refuse to sign the refusal of care form, that's when you can have another person on scene who is not your partner sign for them, whether that be a family member or a friend who's on scene, or a very good person to have sign as a witness to this event is a police officer. So if you have a police officer on scene to attempt to get the patient to go to the hospital already, they're a perfect person to turn to saying, you listened to this entire conversation, you know that they're refusing our care, can you sign to that fact? And fortunately, most police officers nowadays wear body cams that are recording, so you also have the added protection of you have a recording of that entire event that took place. So this just emphasizes the importance of knowing that if you touch someone against their will, it can be viewed in court as assault or battery. Whenever you have a refusal of care, try to have a witness that's someone who is legally of age to sign a legal document, and have them sign below the patient's signature saying that they witnessed the conversation that we had and they witnessed the patient actually signing the form. That way the patient has a hard time coming back saying, oh, well, I didn't refuse care. I didn't sign that form. If you have a witness, that cuts down on the chances of that happening greatly. And it's also very important to let the patient know that if they change their mind about having care or transport to the hospital, they can call us right back, or they can seek immediate medical attention anywhere else. And it's important that they understand that, and that you document that you told them and that they understood that they could do that. So when a patient refuses transport to the hospital and you're going to leave them at their scene or the house, if possible, have a friend or relative remain with the patient. A big one we usually use is spouses, just someone that can watch the patient for several hours and be able to call us back if the patient worsens in condition. They can't call for themselves. And then, as with everything we do in EMS, make sure you document everything thoroughly. Document that you attempted several times to get them to go to the hospital or whatever care that they're refusing, and document that you explained the risks to them, what the risks were, and that they understood those risks, and that they knew that they could call back if they changed their mind or if their condition worsened. So do not resuscitate orders and physician orders for life-sustaining treatment. In New York State, the physician orders for life-sustaining treatment is replaced with what's called a medical order for life-sustaining treatment, or a MOLST form. That's the most common form that we are going to run into. It's a hot pink form, and it's 4 pages long. It's really hard to miss because of its color. But both of these are legal documents expressing the patient's wishes if they are unable to speak for themselves. A DNR is both a DNR and a MOLST form are called advanced directives. DNR stands for do not resuscitate, and that only takes in effect if the patient does not have a pulse and is not breathing. If both of those are present, then that document says that when they were of sound mind and body, they expressed that they did not want to be resuscitated by us. So that means that we do not start CPR or any other resuscitative measures if the pulse and breathing are absent. If you have pulse or if they are breathing, that means that we do have to treat the patient to the best of our ability. Now, a MOLST form can be a whole lot more specific. It still only takes effect if the patient cannot make choices for themselves, so if they can't talk to you, if they don't have the right mental capacity. But a MOLST form is saying the same thing as a DNR, that while they were of sound mind and body, they expressed these conditions that they wanted to be treated at. But this will be very much more specific. You can say that you do not want to be resuscitated. You can say, I do not want an IV. You can say, I do not want a breathing tube. You can say that you do not want to be ventilated with a BVM. You can even say that you do not want to go to the hospital unless if for some reason your pain can't be controlled at home. So most forms are becoming much more popular because you have all these specific things that you can check of what you want, and to varying degrees of what you want. You know, sometimes you can say, I want a trial of this, but I don't want to be put on it for long term. So in class we went over all these forms. If you need, I can send you another copy of this form so you can see what it actually looks like in person. We should also be familiar with living wills and healthcare proxies. Living wills and healthcare proxies, as EMS, we do not recognize. The biggest one that becomes an issue is healthcare proxies. That is a designated agent that someone, when they're of sound mind and body, said, I want this person to make decisions for me when I'm unconscious. A lot of times it's a spouse or a son or daughter. And that becomes a little messy for us because, like I said, we do not honor healthcare proxies in the field. They do in the hospital, however. So you can have a person who's unconscious and a healthcare proxy is screaming at you saying that they want this done, but if there's no documentation for the MOLST saying that we can't do it, we still have to treat them to the best of our abilities. First thing is negligence. That's a word that's thrown around a lot. So think about what you think of when negligence is said to you. For us, negligence is something that should have been done by us, or either was not done or done incorrectly. And there's a few things you have to prove when you're talking about a negligence lawsuit. One of the first things you have to prove for pretty much anything with negligence is that the person had to have a duty to act. So us as on-duty EMTs, if you are called to a scene while on duty, that is your duty to act to treat that patient. The next thing you have to prove is what's called a breach of duty. So if you have the duty to care for this patient, you have to somehow breach it, and that's proved by saying that a reasonable EMT in your situation would have treated the patient this way, and you failed to treat the patient the way that a normal, reasonable EMT would. That'd either be withholding care or providing care improperly. Another thing that you must prove is what's called proximate causation. And that's saying that your acts directly are linked to a patient suffering harm. So whether it's, again, you doing something improperly or you doing something not at all led to a patient causing harm. What this could be is if you refuse to take a patient to a hospital that needed to go to the hospital, and they wanted to go to the hospital and they ended up dying because they didn't seek treatment. If they can link that they didn't seek treatment because you were there and you said that you would not take them to the hospital, and that's what caused their death, that would be proximate causation. Negligent EMTs may be required to pay damages in a lawsuit. Negligence can come both on you, it can come on your agency, and it can come on your medical director. And depending on what you did, it could be all three, just one aspect. So breaching your duty can be a huge thing that will affect a lot of people in a lawsuit. So another legal term that we should be aware of is res ispa locator. It's again Latin, and it literally translates to the thing speaks for itself. And that's sometimes used in negligence cases, and it essentially means that a plaintiff can use circumstantial evidence to prove negligence, saying that because there's no other reasonable explanation for the harm caused, what you did must have been the harm, even though they can't prove a direct link. That could be if you have a patient that you have to take care of the airway and they die because of lack of airway care, but they can't prove exactly what you did harmed them, they can go with the res ispa locator argument, saying that, well, there's no other explanation of why this patient suffocated because of lack of airway care. So even though I can't say your actions specifically caused this, nothing else makes sense. So they can use this as a cause to prove negligence. All right, so expanding a little bit on duty to act. Your duty to act, as we said before, it's your obligation to provide care to a patient. This can get very gray very quickly, and sometimes there's no clear-cut answer of when you have a duty to act. This specifically comes up when you're off duty. Say you're driving home and you come across a car accident and there's no one else on scene. Can you legally just keep on driving by? Usually the answer is yes. If you are off duty, you do not have a duty to act. And some people do that because when you're off duty, you cannot be practicing medicine under the license of the doctor that you typically practice under. If you remember going back to day one, we are certified individuals, so we have to practice under a doctor's license. What helps us in that situation is what's called Good Samaritan laws. Most states, including New York State, have Good Samaritan laws, and they're designed to protect any provider who is giving care when no duty to act exists. So if you, in good faith, are giving good, reasonable care and something happens, Good Samaritan laws protect your negligence, unless it's something gross that you did or you practice out of the scope of your practice. Going with on duty, say you're returning from a call from the hospital back to your station, and you're not in your own district, but you come across a car accident. Do you have a duty to act? That, again, is kind of a gray area because it's not your own district, but you are on duty, and you do have the means and ability to provide the care. Almost everyone in the field will provide care at that point until the transporting ambulance or whoever's jurisdiction it is able to show up. So we have to follow our own local laws and protocols. And really what boils down to is follow your own conscience. If you remember back when we were talking about doing what a reasonable EMT in your position would do, most reasonable EMTs would, especially if they're on duty, provide care even if they're of their jurisdiction. That's going to be the standard that a lot of lawyers will follow. If someone died because you drove off and no other care was available for another 30 minutes. Another key element of your duty to act is called abandonment. And that's if you start care, you have to continue care until it's taken over by something else. Whether it is transferring it to someone of your equal training or higher, so you transfer it to another EMT, you transfer it to a paramedic, you transfer it to a nurse or doctor at the hospital, or until the patient requests that you stop giving care. So that would be a refusal of care. If for some reason you are treating the patient, then you just decide to leave, that could be seen as abandonment. A situation where that might occur is, say you're transporting a patient to the hospital who you're bringing in for toe pain or something very, very basic, and as you're driving by, someone collapses in the street and goes into cardiac arrest. You can't just leave your patient to treat the second patient. You can stop and have your partner treat that patient, but someone has to remain with your original patient and keep on providing care. And this is actually a real life scenario that I encountered at one point. I was in the city of Syracuse, and another ambulance was transporting someone with chest pain, and they literally drove by someone who was dead in the middle of the street, and the call just came in. I was the second ambulance who came for the cardiac arrest patient, but the first crew pulled over. The EMT assumed care in the back of the ambulance and monitored that patient while the paramedic got out and started to provide care to the cardiac arrest until I was able to get there. Because they left someone with their patient, it did not constitute as abandonment, and they are also able to treat the higher priority patient that was literally in the road that they were driving down. So going more on to Good Samaritan laws, as I said, they grant immunity from liability if the rescuer acts in good faith within your scope of practice. It rarely applies to people who are on duty. If you are on duty and you have a established duty to act, then you are kind of exempt from Good Samaritan, because that covers people who are just going about their normal daily life and stumble across an emergency and they try to help. Kind of like if you remember the Bible story of the Good Samaritan. They may cover you in a few situations, but it's mostly only if you're off duty. And they do not protect you from gross negligence or violations of the law or practicing outside your scope, as we discussed earlier. So just because you're off duty doesn't mean you can just go out and do whatever you want, but it will protect you from minor things. So here are a few situations. So if you arrive on the scene of a patient in cardiac arrest, but the family says that they have a DNR, which is do not resuscitate, as we talked about, but they don't know where it is. How can you handle this? So this is something that happens in real life all the time. This is why we tell people who have a DNR to post it someplace where it's easily found. A lot of times we say post it on the fridge, and we will look at the fridge. Someplace where a stranger should be able to look pretty easily. That's also why they made the most forms the hot pink form, so it sticks out in a sea of papers. So this does come to a gray area, because in order to honor a DNR, we have to be able to see the DNR. Otherwise, if you collapse and your spouse just really wants you to be dead, they could be the one who murdered you. They can just say, oh yeah, he has a DNR, I can't find it, but he definitely didn't want anything done. And that's what they're saying just for their own benefit, and it's not what the patient's actual wishes were. So on the flip side, most of the time, people do have a valid DNR and do not want anything done. It's just the family can't find it, especially in the panic of their family member just suddenly died and they can't be thinking straight. So this poses a lot of questions for us on how to handle it. A lot of times it helps if there's more than one family member agreeing with the story. saying that the person did not want anything done. And look at the circumstances of the patient. If it's someone who is on hospice care, this was an expected death, chances are very high that they did actually have a DNR. If it's a 25-year-old who is in good health, the chances of them actually having DNR are pretty slim. So one of the best things you can do for this is contact medical control. So you can call the resource hospital, which would be upstate, or your agency medical director, and explain the situation to them and get their advice. A lot of times, if you explain it right, say, it's a patient in their 80s who has an extensive medical history, who has been sick for a while. The family is claiming that he does have a DNR, but they can't find it right now. They're expressing greatly that we do not resuscitate the patient. A lot of times you'll get the doctor to say, that makes sense, withhold resuscitation. And if you get a doctor to order that you withhold the resuscitation, that can be a valid reason to not resuscitate someone. But if there's any doubt in your mind that there is not a DNR, or that someone wanted something to be done, then just go ahead and do it. It's better to resuscitate because you can't see the DNR, or the DNR is not valid, than to not resuscitate and end up having someone who really wanted something to be done. Second question. You were off duty and arrive on scene of a vehicle crash. Police and EMS have not yet arrived. Are you legally obligated to stop and render aid? So the short answer is no. If you're off duty and you come up on a vehicle crash, legally you do not have to stop and render aid. This comes down to personal conscience, and a lot of times it's situation dependent. If it's a minor fender bender, then it looks like everyone's moving around is okay. A lot of times I'll drive by that. If it's someone who, it looks like a major crash and you see someone who's slumped over the wheel unconscious, then it's kind of a different story, at least personally to me. If it's something that I can fix with my bare hands with no equipment whatsoever, then it's going to be much more of a reason for me to stop. A lot of the rationale I give for not stopping is when you're by yourself, you don't usually have equipment to help patients, and there's very little that you can do with just your two hands and no other equipment. So it comes down to a judgment decision. Are you legally held to the standard that you have to stop and help? No. But a lot of people do, because then that weighs on you that someone could have suffered or died because you weren't able to provide care, or you chose not to provide care. And especially in rural Oswego County areas where help might be 20, 30 minutes away, that could mean the difference between someone living and dying. So going on to confidentiality. Confidentiality, we have to keep on all information we gather from a patient. So that includes their medical history, their name, their date of birth, their social security number, their address, the condition that we found them in, and the treatment that we rendered them in, and the condition we left them in. All this has to stay between us and the patient. We cannot provide further information to other sources. Where this comes into play is if you're at a house fire or you're at a car accident that is a big event and the news comes and they want to get a story on what happened, they'll oftentimes ask you, oh, well, was anyone hurt? How badly were they hurt? How are they doing? And that's something that we have to remain confidential and not disclose to other people. The major law that confidentiality falls under is called HIPAA. It's the Health Insurance Portability and Accountability Act, HIPAA. It's very commonly misspelled HIPPA, but it's HIPAA. HIPAA covers information shared with healthcare personnel as part of a patient's continuing care. So if you bring someone to the hospital, HIPAA allows you to tell the hospital their healthcare information. So their name, date of birth, address, what happened, basic things that you think you should be able to tell someone who is about to assume care. If the information is not required to continue care for the patient, then we are not allowed to disclose it to anyone else. So, we can give the information to the receiving hospital for registration, for the nurses and doctors to continue care, but we can't go and give it back to a primary care that we picked them up from, because they're not continuing the care that we had. If for some reason anyone else needs the patient information, then they must be obtained through a subpoena. So we'll see that if we go to a car accident and the patient is injured, then they want to sue whoever hit them, both lawyers will subpoena our chart that we documented about the call, so that they can see what happened during the call, what you did, what the patient's information is, and all that, but that has to come through a court order. So, medical information devices. Some people wear these. I'll admit I am not the best at looking for these, but they are very useful for someone who's unconscious that no one around knows them. Fortunately, usually when someone's unconscious and can't talk for themselves, someone else who knows them is around. Things that can go on a medical alert bracelet are allergies, major medical conditions such as diabetes, anything that might cause them to not be able to communicate with us. So typically it's either a bracelet or a necklace, and it will, as you can see on the screen, say medical alert on the front, and on the back it's in metal and engraved, and it will say usually their name, date of birth, and then any major information that we need to know. So allergic to bees or has diabetes, one of those things will be on there. It is a nice way to make sure that we can get all the information that we need to treat the patient if no one knows them and they can't speak for themselves. So organ donors, they complete a legal document allowing donation of organs and tissues in the event of death. Usually you can see that on their driver's license. There will be a little heart on the New York State driver's license. And the receiving hospital of the patient or medical direction, if you call to terminate resuscitation, should be advised that they are an organ donor. Sometimes if someone has a traumatic death that we know that we can't bring them back to life, if you call and talk to the doctor about terminating the resuscitation and you say that they are an organ donor, they'll say, well, let's keep on continuing the resuscitation, bring them into the hospital, see if we can salvage any of these organs so that they can be donated. Another special situation is safe haven laws. They allow a person to drop off an infant or child at any fire, police, or EMS station. Different states have different guidelines for the ages of children included. Usually it's down to very small children and babies, ones who can't remember the event. And they allow us to protect children who may otherwise be abandoned or harmed by parents unwilling or unable to care for them. So it's usually no questions asked. The parent will come and say, this is my child, I don't want them anymore, and they hand them to us. We then have to contact social services and have the child given to them, and they will take care of the rest from there. But it allows public buildings that everyone knows about access to be able to drop off these children, which protects them from abandonment or mistreatment. So crime scenes are another special situation. A crime scene is any place where a crime has been committed or any evidence might be found. Once police have come and made the scene safe for us, our priority is to the patient. Preserving a crime scene is secondary to patient care. Try to be mindful of the crime scene. Don't go trudging through a house and kicking everything around that you can see. But if something of the crime scene is impeding your ability to treat the patient, you have to move it and get to your patient. So it's more of a just be aware of your surroundings issue. Know what evidence is. If you pull up in the road and there's a bunch of shell casings from a gun in the road, don't be kicking them around, try to walk around them, and know other things that police might consider evidence, footprints or fingerprints or anything like that. Just know what they might want to see, and then take steps to preserve it as best as possible, again, without impeding patient care. There can be something with a bloody handprint on it from a perpetrator, but if you have to move that to access your patient, you have to move that. It is much more important to treat the patient effectively and immediately than to preserve that crime scene if it gets in your way. So some examples of the evidence are the condition of the scene. The patient themselves might have a lot of evidence on them, any fingerprints or footprints, and then microscopic evidence that could be DNA or, as they just said, fingerprints or anything that we won't be able to see ourselves. So be mindful, even though you can't see it, it might still be evidence. So keep in mind, remember what you touch, minimize your impact on the scene, and work well with the police. That's a general rule of thumb for every call, is try to work well with police departments and fire departments. We're all a team for emergency services, and we don't want us arguing with each other or not letting each other do each other's jobs properly. We're all here to help each other, and for the most part, we all work hand in hand very well. Some ways to help with the crime scene is make sure that you're wearing gloves before you enter the house. That will minimize your fingerprints on the scene, because if they're dusting for fingerprints, yours will be found, and a lot of times your fingerprints will be in the system based off of the job that you have. Some fire departments fingerprint, some ambulance companies will fingerprint you. So minimizing their work of trying to eliminate responders from the fingerprints that are there is huge. So try to put your gloves on as early as you can, and remember what you touch and try to minimize what you touch. Make it only for patient care. So some special reporting requirements. Child, elderly, or domestic abuse, oftentimes we have to report that. One thing that we definitely have to report about is child abuse. In New York State, we are what's called a mandated reporter. That means if you see child abuse happen, you are mandated, required by law to report it. And if you end up failing to report it, and someone finds out that the abuse happened and you saw it and you fail to report it, you can be legally held liable for that, both civilly and criminally. Other reporting requirements are violence, gunshot wounds, or stabbings. Typically, if we report to the hospital will report to police. But if you show up on a scene of someone who was shot or stabbed, you should be calling for police as it is. You should not just be going on your day like, oh, okay, well you're stabbed. All right, well let's go to the hospital. Let's not tell anyone. Other ones are sexual assault. Again, if you see sexual assault, call police to the scene. And if someone is in such bad condition, whether it's a shooting, stabbing, or sexual assault, if time is of the essence, call for the police, but you might say that the police have to meet you at the hospital as well. Don't delay transport just because you're waiting for police to make a report. And some other reporting requirements are situations where restraint is necessary. As we discussed with mental health patients, if you're restraining someone, police should be involved. If you're taking someone against their will to the hospital, police should be involved in some way. Again, if you can, try to have police there before you do it. But if your safety is at risk, you can go ahead and do it and call for police, and either they can meet you on scene or on the way to the hospital or at the hospital. So some intoxicated persons with injuries, you should be reporting to police, and some mentally incompetent people with injuries. So this could be someone who has mental retardation, lives in a group home, and you notice that they have a lot of bruising on them, or they have evidence of some sort of assault. That's something that we should be reporting to the police and possibly to the Office of Social Services. Definitely to the hospital. Report any suspicious activity. Anytime that you suspect any sort of abuse in someone who cannot fend for themselves, that's something that we should be reporting. So, medical, legal, and ethical issues are a part of every single EMS call. Consent may be expressed or implied. If a patient who is awake and oriented has the capacity to fully understand his situation and refuses care or transport, you should make every effort to persuade him, but you cannot force them to go to accept care or go to the hospital. If you remember, consent being expressed is someone telling you that they're giving you consent, and implied is someone who is unable to talk to you or legally make their own decisions. We are implying that if they were of sound mind and body, they would be giving us consent to care. Negligence is failing to act appropriately when you have a duty to act. As a EMT, you have a duty to act whenever you are dispatched on a call and you are on duty at the time. You may have a legal or moral duty to act even if you're off duty or outside your jurisdiction. Typically, when you're off duty, you do not have a legal requirement to act. But if you're outside your jurisdiction and you are on duty, that's where it becomes much more acceptable to be providing care. And sometimes a lawyer could prove that you had a reasonable duty to provide care because any other reasonable EMT in your situation would have. Abandonment is leaving a patient after you have initiated care and before you have transferred the patient to a person with equal or higher training. If a patient refuses care or transport, that won't come into abandonment, but that's why we also get a signature saying that the person is refusing care, and we try to get a witness to that so that they can't claim that we abandoned them because they were refusing the care. Confidentiality is the obligation not to reveal personal information you obtain about a patient except to other healthcare professionals involved in the patient's care or under a court order, or if the patient does sign a release themselves. This oftentimes comes for if the patient wants to see a chart themselves that was written about themselves, they can sign a release saying that we can release the information back to them. Other times you really need a court order, a subpoena to disclose this information to someone who is not directly involved in the next steps of patient care. HIPAA is a huge part of what we do, and almost every department is required to give you specific HIPAA training before you're allowed to go on call so that you know what you can and cannot disclose for information. As an EMT, you may be sued or held legally liable on any of these issues that we discussed today. However, EMTs are rarely held liable when they've acted within their scope of practice and according to the standard of care and have carefully documented the details of the call. Remember, standard of care is when you're asked another EMT of reasonable training on the same level as you, what they would reasonably do in the same situation. I've been providing care for over 10 years now, and I've gone to court to testify in criminal cases, but I've never even come close to having someone sue me as an EMT providing care. Typically, and I've seen a lot of patients who have brought lawsuits against others, typically it's about the hospital. At a crime scene, care of the patient takes precedence over the preservation of evidence. However, you should make every effort not to disturb the scene and unnecessarily and report any of your actions and observations to the police, especially if you roll up on a scene that you don't know is a crime scene and you weren't dispatched to anything that you would wait for police for, and then you find out that it was a crime scene. Tell them what you did before you got there, anything that you moved, anything that you touched. Work hand in hand with police. It goes a long way. Remember that EMTs must use good judgment and decision-making skills when dealing with a patient who's refusing care or patient consent. And avoiding negligence implies using good judgment. Critical thinking is an essential component for avoiding liability. Also remember, going with HIPAA, that EMTs hold responsibility for patients' protected health information. Exercising care when dealing with this information is a legal and ethical obligation, making sure that we do not disclose this to anyone who does not need it to continue patient care. Some questions that we should consider. So, remember to be able to define what scope of practice is, negligence, duty to act, abandonment, and confidentiality. All these will be tested on, so remember how to define these things. What steps must you take when a patient refuses care or transportation? If you remember back, steps that we have to take are making sure the patient is legally able to refuse care. So they have to be alert and oriented, not under the influence of drugs or alcohol, not suicidal or homicidal. And once they do that, you have to explain the risks of refusing care. They have to understand those risks of refusing care. You have to offer them that care several times, and they have to refuse it several times. And you have to let them know that if they change their mind or if their condition changes, they can always change their mind and call us back or accept the care that we are offering. What types of evidence may be found at a crime scene? And how should you act to preserve the evidence? So as we discussed, anything microscopic could be found, so things that you can't even see, like DNA or fingerprints. It could be shell casings from a gun. It could be any other weapon that may have been used. It could be drugs. It all depends on what type of crime scene is there. And we should try to touch as little as possible, move as little as possible, and disturb as little as possible, but still keep patient care as your priority. Next, you are responding to a motor vehicle crash and find a seriously injured patient. He has no pulse, and you're about to begin CPR when someone says, "No, don't do that. He's got cancer and a DNR." No one has the DNR at the scene. Do you start CPR and transport the patient? So again, this comes into kind of a gray area. All things considered, if you err on the side of performing care, if you do not have something that you can see saying that you legally don't have to do care, then that is the safest way to go. You won't be held liable if you do not have exactly what you need to withhold care in your presence and you do care anyway. You could be held liable if you withhold care and it turns out that there's nothing saying that you shouldn't have done care. So in this particular situation, I personally would start CPR because you don't know who this other person is. You don't know if the patient actually has cancer. You don't know if they actually have a DNR. There's far too many unknowns. The only time that I really think about withholding care, if we can't find a DNR, is if they're at home. You have several family members giving you the exact same story. They're all saying that he wanted absolutely nothing done. And even then, that's when I'm calling medical control and explaining the situation to them. So in most other situations, go ahead and provide the care. So that brings us to the end of this chapter. We covered a lot of ground. If there's any questions, feel free to reach out to me. If you want to see any of these legal examples, again, feel free to reach out to me, and I'll forward you some stuff that you can look over. And keep all this in mind. This is stuff that pops up on every single call that we go on, and it's stuff that can ruin careers if you act negligently, or if you break confidentiality, or if you do something that is against the patient's wishes.